What we discuss in this podcast is general information only and is not legal advice. Also, our discussion does not give rise to a solicitor-client relationship between us and you, our listeners. If you are currently facing any issue or problem, you must obtain your own independent legal advice. Some law firms provide a non-obligatory, free of charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own. They do not reflect the values, opinions, and practices of our firms, friends, and families.
So if your relationship with your spouse breaks down, what happens?
Okay, so in divorce, we generally have two different types. One would be contested and one would be uncontested. So since T is the expert, I'll let him do the difficult one, which is the contested bit. I'll just do the uncontested
Maybe the
one.
uncontested one is less easy.
Yeah. As T previously mentioned, there are two stages in a divorce. The first is the grounds of divorce, which is telling the court why you want to get divorced. So some of the most common examples are adultery. Generally, to be honest, I don't encourage people to go under the ground of adultery because what it requires is a PI report, which has to satisfy two things. Because in the past, the standard of proof for adultery is you needed to literally go into a hotel room and take a picture of them having sex together, and that is adultery. And of course, over the years, that requirement has lessened. So now all you have to prove is timing and opportunity. So if you manage to take a picture of two of them going into the hotel together, that will be sufficient to meet the timing and opportunity. But you still need to get a PI report, which for somebody who perhaps, if you are young and you don't earn that much money, or if you have no job at all, you depend on your husband for finances, then getting a PI report may not be so feasible. What we do is we recommend just go under unreasonable behavior and put your reason as inappropriate association with a third party. And generally, courts don't really investigate the reason. So that's the grounds of divorce. That's the first stage. The second stage is ancillary matters, where you decide how you want to split your assets, how you want to split your kids, how you want to split the dog, all that. And generally for an uncontested divorce, you can do both stages at once in one filing. So you come down to my office, I draft all the paperwork documents for you. There are 5 documents that I'll need to prepare, and then you can sign off on them, and I can file them all at one shot. And assuming that there's nothing too wrong with the paperwork, generally nothing's wrong with the paperwork, the court will give you a date. And this is an administrative hearing date. You don't have to turn up in court. Even your lawyers don't have to turn up in court. The judges will go through the paperwork. They'll say, okay, all your papers are in order. I'm going to grant you the interim judgment immediately. So that takes about 1 month or so. In the past, we used to get hearing dates a lot faster. But recently, I've realized that the waiting time for hearing dates has gotten longer and longer. So for my last uncontested divorce that I filed, I had to wait almost a month and a half for a hearing date. So you file paperwork, you wait a month and a half, you get your interim judgment. And then thereafter, there's a 3-month mandatory cooling off period. So I've had clients come to me and be like, oh, I've gotten my mistress pregnant, I need a quickie divorce. Can we shorten by consent the 3 months? And the answer to that is no. You can't shorten the 3 months. And it's mandatorily provided to try and encourage parties to work out their differences. So within those 3 months, if you decide that you want to reconcile, take back your divorce papers, you can do that with no consequence, except for a little bit of cost consequence. Once the 3 months is up, you get a final judgment, which states that, okay, you've agreed to all these different things, and I now order that your divorce be made final. And so you bring this final judgment order to all the relevant places. So if you have a HDB, you bring the order of court to the HDB, and you tell them, okay, this is the order, can you please effect it? And HDB will be like, okay, yeah, I'll effect it.
So you say that this is uncontested. What does that mean?
So that means that none of the ancillary matters contested. So basically, it's where, as a wife, you say, I want half of the HDB. And then the husband goes, okay, I'll give you half of the HDB. And then we put it out in writing. Each one get half of the HDB. And then the children, maybe the wife says, I want maintenance for children at $100 a month. Husband says, okay, I'll give you $100 a month. So you put it in writing, $100 a month. Then after that, you have maybe the dog. I want to keep the dog. Husband says, okay, you can keep the dog. Put it down in writing. There was actually a lot of arguments as to how do we treat animals in divorce proceedings. Whether or not animals should be treated as children where custody, care and control orders are given, or whether animals should be treated as property. But essentially an uncontested divorce is one where everything is agreed on by the parties. So it's a matter of just putting the agreement down in writing.
And that may apply to the grounds of divorce stage as well. So you mean somebody can agree that they themselves committed adultery?
Yes, usually what happens at the grounds of divorce stage is you have to file a document called Statement of Particulars. And the Statement of Particulars sets out all the reasons why you want to get a divorce. And this is usually very hotly contested if there are grounds like adultery. So what generally happens is, as a plaintiff's lawyer, so if I'm raising the divorce, I will just write the most ridiculous things in the Statement of Particulars. I will try and go as far as I can. So for instance, I had one case in the past where I represented the wife and they were a very old couple. One of her chief complaints is that he's too old to get it up, but yet he wants her to perform oral sex on him every night before he goes to bed. And this made a very terrible living situation for her because she's old and she's too afraid to go home. And when she doesn't provide oral sex to him, he would strangle her. So this is an actual case I handled where I represented the plaintiff. I'm not even joking. This actually happened. So I wrote all the exciting details. And the response from the other party's lawyer will always be, okay, so you're going to take this out, 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 you're going to take this out. So you get a response back of everything they want to take out from the Statement of Particulars. And then you'll be like, okay, as long as you're agreeing to divorce, I'll take it out. So it's more of a negotiation strategy, taking a position on certain things and then giving it up later so that they can agree to something else. So it's all about really negotiating, I think.
What if parties just had agreed that they wanted a divorce? Why is it that parties still need to prove grounds of divorce, reasons for divorce? Can't they just go to court and say, we have agreed to the divorce, and the court just approves the paperwork?
It has to do with the sanctity of the marriage. Marriage is an institution that needs to be respected. So if you want to call it quits, you want to end the marriage, then under the law, there are still certain requirements that need to be satisfied, and just the consent between parties is insufficient. Before I go into the grounds, there is also the 3-year time period. So that shows that marriage is treated as something which is important and that it's worth preserving the sanctity of marriage. So before 3 years, you can't get a divorce. You have to be married for 3 years, and then afterwards, if the marriage is broken down, you can get a divorce. So that's just an example of how, under the law, just because parties agree, it doesn't mean that the court would simply give the divorce. The test would have to be satisfied. For divorce, currently under the law, we have adultery, unreasonable behavior, desertion, 3-year separation, and 4-year separation. You would have to tell the court that these are the reasons why we are getting a divorce, and those reasons would have to fall under any one of these categories. But I think that there is another ground that they are adding to the Women's Charter. I think it's to make it easier for parties to get divorced, and I think it's got something to do with the agreement between parties.
Yeah, so this is what has been currently debated in Parliament. So I think Sun Xueling was the one that came up to explain what the new amendments are. But moving forward, the courts are going to try and make it less acrimonious by allowing parties to agree to divorce. That will be the main and chief change coming up. But this has not been enacted yet. We don't know when it's coming in force. I don't have the exact details.
But that's all very fascinating. And we have been talking quite a lot now about uncontested proceedings by agreement, by consent. What happens if proceedings are contested?
And maybe how much it would cost to go to court.
So the question is, what is being contested? Most divorces in Singapore, at least as far as the grounds for divorce is concerned, parties usually settle. The courts also try their best to get parties to settle. That is because if you cannot settle on the grounds for divorce, then you go for a full-fledged trial, which means that parties would have to take the stand, their affidavits would have to be filed, there will be cross-examination and all of that. And usually what lawyers tell their clients is try and settle the grounds for divorce, because in most cases, the grounds for divorce is not going to have an impact on ancillary matters. So very rarely do parties go for a contested trial, and you can expect fees to be anywhere in the range of $15,000, $20,000, because lawyers generally for trial, they usually charge on a daily basis, right? So 1 day of trial, let's just say about $4,000, $5,000. So if you have a line of witnesses who are going to take the stand to prove that the other side is unreasonable, and then parties themselves also take the stand, easily you would have at least 1 or 2 days of trial. And to spend about $10,000, $15,000, $20,000 or more than that, because affidavits would also have to be prepared for an outcome which is not necessarily going to have an impact on the future, is it really worth it? So that's one side of contested proceedings, is the trial for the grounds for divorce. And then there is the ancillary matter. So if ancillary matters are contested, then there will be affidavits that need to be filed. Subsequently, there will be a hearing in chambers. So there's no trial where parties take the stand and cross-examination, all of that. Generally, the hearing is conducted in chambers, which means that the court looks at the affidavits, the evidence that is in the affidavits, hears the submissions of parties or their respective counsels, and the court will make orders.
What are the matters to be decided in the ancillary stage?
Division of matrimonial assets. That's usually decided based on parties' contributions, direct or indirect contributions. So how much they've paid for the property, how much they've paid for groceries, who contributed more. And it also involves finding out the pool of matrimonial assets. So all the assets acquired by parties in the course of marriage typically would be considered as a matrimonial property. So the court deals with all of these issues, and then the court will give an order saying that, okay, husband 30%, wife 70%. The property is to be, for example, sold in the open market, and then the net sale proceeds will be divided. So that's the kind of thing that happens with the division of matrimonial assets. That's one. Secondly, it's maintenance. The husband has to pay wife maintenance of X sum of dollars, and for the kids as well. That's maintenance. And then thirdly, there is the child-related matters, custody, care and control. Usually it's joint custody, but for care and control, of course, that's a question as to who is going to look after the child on a daily basis. So is the child going to stay with the mother or going to stay with the father? And if one party has care and control, then the other party will have visitation rights, which is what we call as access.
Maybe let's explain what the difference is between custody and care and control, because I realize that there's a lot of confusion about these two concepts.
Yeah. Sometimes I just simplify it this way for clients. Custody has to do with the big issues in a child's life. Care and control has to do with the day-to-day events.
So I think there are specific categories that fall under custody. Maybe you want to talk about the specific categories.
Like joint custody and...
No, so I think what we talk about the big issues, we talk about medical decisions, right? So,
yeah.
So if you want to decide on a life-changing medical decision for your child, then both parties need to agree under joint custody rules.
Yeah.
Then educational decisions, where the kid goes to school, which school, all these are major decisions that must be made jointly under joint custody. I think the third one is religion, right? So if you want to change your child's religion, then that also has to be a joint decision between both parties under joint custody rules. So those are the three main areas for joint custody.
And how about care and control? Does a child get a say in all of this?
Yes. Typically what happens is that if the child is, let's say, closer to the mother and that parent wants to have care and control of the child, then in the proceedings they will say that this is the interest of the child as well. And so if the child is closer to the mother and the mother wants care and control over the child, then the mother will tell the court that this is what the child desires, and for the child to be removed from me and made to live with the father is going to be detrimental to the psychological and emotional welfare of the child.
Actually, this is a very interesting topic, because in the past, what the courts have witnessed, and this has resulted in some changes in how we operate in terms of custody and care and control. But in the past, the courts have seen that there are certain parents that use children as a bargaining chip in the divorce process. And there was this one very big case that you can read about in Straits Times where the mother was manipulating the child so that the child would raise sexual assault charges against the father that were eventually dismissed. But what they realized is there are a lot of people manipulating children for or against one or the other parent. So a lot of different kind of strategies have been employed by the courts to ensure that this doesn't happen. So some of the judges can actually sit down with children without interference from their parents or counsel. So they can have a private sit-down meeting. But another, I think, more important strategy that has come in place in the recent years is to have a child representative. So if you go into a lot of family lawyers' websites now, you will see that some of them actually state, I've been appointed as a child representative. And so this child representative can make recommendations to the court. For instance, the child representative can say, I've spoken to the child and I think that there is need for counseling, that I think that one party is poisoning the child. So they work in the interest of cause of justice, and they're not beholden to any one party because that one party is paying their legal fees, for instance. So that is a step in the right direction. It's also part of this idea of therapeutic justice, which is why I say therapeutic justice is more of an alignment of what's already in play, moving down the same road, as opposed to something entirely new. But okay, moving on.
Let's talk about division of the matrimonial pool. And I suppose something that really is on many people's minds is if I have assets in my own name, then you'll be safe from division, right? I mean, the other person can't get it. What's your answer to that?
No. That's a very straightforward no. So as I mentioned before, there's a lot of tests that we have to satisfy in court. So the test for division of matrimonial assets is, the first question is, what is in the matrimonial pool? So T, you wanna...
So there are, I think broadly there are two types of assets here. The assets that parties had acquired for themselves, that's in their sole name before they got married, and then the assets that are acquired after marriage. So assets that are acquired after marriage, even if it's in sole names, it is still part of the pool of matrimonial assets. That's just the general rule. And as for assets that were acquired before marriage, if it has been improved or enjoyed by parties during the course of the marriage, then that would fall under the pool of matrimonial assets. So these are just the two broad tests to determine what are matrimonial assets.
I will go further and say that there are certain exceptions to this general rule. The question that you need to ask yourself is, does this property or does this asset take on the nature of a matrimonial asset, which is the test of enjoyment or improvement. But let's give an example. I think we work better in these cases. For example, say I am now 40 years old. When I was 35, I bought a HDB flat in my own name. And thereafter, I met a man. I fell in love with this man. We got married within half a year. He moves into my HDB flat. And we've been married for about 6 years. And now we want a divorce. But that flat is still under my name only. Would he be entitled to get a portion of my flat?
He would. Because that's it's even though it's an asset that you had purchased before marriage, it's an asset that was jointly enjoyed by parties. That's where parties lived, right? So it would be a matrimonial asset. Then of course there's a separate question as to how much. Then there are further tests that would determine that.
Okay, then let's talk about the length of my marriage. My marriage to him was only for about 6 or 7 years. Okay, so would he automatically be entitled to half the HDB?
Right. So when it comes to determining how much, then the court looks into direct contributions and indirect contributions. So traditionally, if it's a short marriage, then the court is going to place more weight on direct contributions. How much did he pay? How much did you pay? And if you were the one who had procured the flat before the marriage, then the chances are that, and if you're the sole owner, then when it comes to direct contributions, it's very likely that you would have paid for most of the property, or if not for the entire property. And then his contributions is either going to be very little or none. But if it's long-term marriages, then the court is going to place more weight or perhaps equal weight to direct and indirect contributions.
Okay, well, let's take this example further. Say we go 20 years down the road. So we've now been married for 26 years. I have always been the provider of the family. So I'm the one who goes out and brings in the paycheck. I pay for all the bills. But my husband is a stay-at-home husband. And so we have 3 kids together. But throughout our children's lives, he has been the one who cooks and cleans and makes sure that our kids go to school on time. He's the one who's been there as emotional support for our children. He was the one that brought my daughter to buy her first pad. He's the one that, prepared my sons to go to army. And he's the one who helped them through life decisions. So for 26 years, those are the roles that we played, right? So would the division now be different? Yeah,
so the starting point would be 50-50. That's because someone's got to stay at home and look after the kids and contribute in an indirect manner, and the court acknowledges and recognizes that.
Okay, maybe then I'm going to bring us to a more controversial question, which is, would the husband be entitled to maintenance?
The situations in which a husband is entitled to maintenance is very specific. It's only in very limited situations a husband can claim for maintenance, and that's provided for in the law. One such scenario is when the husband is disabled or suffers disability. So in those kind of situations, the wife can be ordered to pay maintenance to the husband.
But in this case, my husband hasn't been working for 30 years because he's been a stay-at-home husband. Can he apply for maintenance? Because he can't. He's probably 60 years old. He can't find a job,
Well, he can't. He can't. So that's not an exception that's been provided for. Maybe one day we will move in that direction. Whereas if it was the other way around, where the husband has been the one who's working and the wife has not been working but has contributed to the family, like most mothers do, right, in the more conventional family setting, providing for the family in an indirect manner, may not be necessarily the breadwinner, but they look after the kids, they clean the house, they contribute in a variety of ways. In that kind of situation, in most situations, the husband will be ordered to pay maintenance to the wife.
Yeah, so I guess my question is, is the law fair, right? Because I think that's the gripe that most men have with the Women's Charter, is that they feel that it's not really very fair to men.
In fact, it's inherent in the name, isn't it? Women's Charter. Is it meant to protect women in that sense?
I have my own thoughts about the Women's Charter, but maybe let's just go back to the original question, which is, in terms of maintenance, are we still at an unfair state? So my answer to that would be yes. Unfortunately, we're still at quite an unfair state. And I will delve into the reason why I don't think this is a problem in a bit. But maybe we can have a decision from T. Is it unfair?
It is, because it's still based on gender, right? It's not really equal. Husband can only seek maintenance in very limited scenarios, whereas wife, there are no specific situations which they have to be confined by, like the way that. So in that sense, it's unfair. And society has obviously changed. So perhaps the law is not keeping up as fast. But that's natural, right? For almost anything. Society changes first, then after that, the law would be amended. Maybe over time, there will be further changes where the rules are equal for when a husband and when a wife can claim maintenance against each other.
Okay, so I actually have a very different perspective. Even though I do think it's unfair, I don't think this will be a problem, or this should be a problem or cause for concern. And the reason why I think like this is because I think about the problem from a more macroeconomic perspective than more microeconomic. Because when we talk about examples, what we're thinking about is how the law impacts one individual. But we don't think about how the law impacts maybe 100 cases or 200 cases or 300 cases. Because the goal of the law really is to standardize procedure. We need a system where it helps majority of the people as opposed to a minority of the people. And I think the reason why this won't impact society is because from a macroeconomic perspective, there is still significantly higher labour force participation of males than labour force participation of females. And I think the difference as of 2018 is about 20%. So I'm reading off statistics from mom.gov, stats.mom.gov. About 90% of the male population are labour force active, but only 70% of the female population are labour force active. And within those percentages, men generally earn significantly more than women, and men generally take on a lot higher paid positions and a lot of the PMET positions as opposed to women. And women tend to be in jobs that are lower paid and are more clerical and administrative in nature. But my point is that if this is the situation for majority of people, then we should have a law that addresses majority situations as opposed to minority situations. For instance, the example that I gave, where the woman is a breadwinner and the husband is a stay-at-home husband, in Singapore society at least, that's still not common. That's still not the majority situation that the law is trying to correct. The law is still very much trying to solve the problem of the majority situation, which is where the husband is the breadwinner and the wife is a stay-at-home mother. So I think as long as the majority situation is still this, then we need a law that addresses the majority situation. And I think that's what we're doing now. Even though I think it's unfair, I don't think there's a real need to change the law yet until we either reach a state where there's equal participation in workforce, where there's no gender wage gap in terms of men and women, where the situation where the woman is the breadwinner and the husband is the stay-at-home husband becomes more common. Only then should we advocate for a change in the law. So I know that I take quite a controversial perspective on this topic. So, anybody have any other ideas?
Maybe my question is, if you just make it equal now, that means you don't think about it in terms of majority or minority situations. There are general tests that you can have. You look at that particular marriage, you find out who earns more. So it could be the husband or it could be the wife. And then based on that, the court is empowered to make maintenance orders based on just if there is a need for maintenance and the ability to pay maintenance. So if you have that kind of just general test, do you think that the majority situations, would they be prejudiced in any manner? Can't you just have general tests, and then if the case before the court is a majority situation or minority situation, it doesn't matter. The court is just going to ask certain very broad questions as to who earns more and whether there's the ability to pay maintenance. Your majority cases won't necessarily be affected, right? So in that way, the court can handle both majority situations and minority situations equally based on this general test.
I mean, that's a food for thought for me, right? So my immediate response would be, you're right, that a general test would address these issues. But my concern really is that there is still a need for protection of women, which is the intent of the Women's Charter. I think that there are many women who still take on the role as sole home carer.
I wonder what G thinks about this. Do you think that more equal general test means less protection for women?
My short response is I do think that there should be attempts at reforming, because while it is true that as a whole there is an undisputable gender wage gap, the current test, which completely prohibits giving maintenance to men, will result in injustice in very specific, very exceptional cases. And I suppose the current approach doesn't accommodate for that at all. Because that's my own perspective.
Yeah, I guess we would have to wait and see if the law changes in this regard.
What we discuss in this podcast is general information only and is not legal advice. Also, our discussion does not give rise to a solicitor-client relationship between us and you, our listeners. If you are currently facing any issue or problem, you must obtain your own independent legal advice. Some law firms provide a non-obligatory, free-of-charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own. They do not reflect the values, opinions, and practices of our firms, friends, and families.